Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Intersentia, and it's called Family, Forms and Parenthood. Not the best of titles, I have to say, because it doesn't really put across what this book is about. It has a subtitle, Theory and Practice of Article 8 of the European Court of Human Rights in Europe. In other words, it's looking at the way in which Article 8 operates. But of course, as I say, the title is a little bit misleading. It's been edited by two people, Andrea Buchler and Helen Keller. Now, Elizabeth and I talked about this book to try to understand what value it would have for us in England and Wales, and quite a lot, of course, even though we are leaving the EU and possibly the convention at some stage in the distant future. Now, our title for the book review for this was Family Law in Europe and the Debate on Article 8 Revisited, because that actually is what the book is about. Let's have a look at it very quickly. It's a paperback, there we are. That's the front, the spine, and then you can see the back there. It runs to some 550 pages. There's a bibliography at the back of each main chapter. There isn't anything like a proper index of any sort, because you have effectively at the back of each chapter a certain amount of information. The front of the book, I'll show you, there's the front page there. Main front page there, and then that's the other books in the series. There are quite a large number in the series which Intersentia have produced. That's the information concerning the publication itself, and then we get into acknowledgements which are quite substantial by the two editors. Then you have the basic structure of the book, which you can see there from the contents page with various part numbers. There are 3 parts and conclusions come right at the end. What I did find helpful were the ECHR cases, which I think are also of great assistance. There aren't that many of them, but they will be of help to you if you are pursuing an Article 8 matter. Now, these are the people who contributed to this publication. Quite a large number, as you can probably see. Very high academic content, as to be expected from Intersentia, who are a first-class publishers of books. The only thing I would say is beware, because obviously the language issue comes in, because there is translation. Now, with each chapter, you've got a nice little index to the chapter at the beginning, and then it runs through with basic body copy. You can see that there are footnotes at the bottom of some of the pages, and as I say, when you get to the end of each chapter, you have a bibliography, which is quite helpful because it gives you further reference. What I do like is the logic of a conclusion to each of the main chapter headings. It's a good book, this one, and let me tell you a little bit about what we think of it, so that you've got some idea of whether this would be of any interest to your practice or not. We say it's published by the Belgian firm of Intersentia, which specialises in family law titles, and this book is aimed both at academics and practitioners in family law, particularly those whose areas of interest is in cross-border family law issues, and who may well have a challenging time of it keeping up with the continually changing face of what is a sensitive and complex subject. And Article 8, of course, is emotive, let's face it. And with the way that we're going globally, we are going to get more of these issues cropping up. That certainly happens in my practice, and I'm sure it does for other people. Of course, the most profound change is Brexit, and the wider impact of which will certainly result in some form of change, I would think, in the future. That's, of course, by the United Kingdom government, and that will probably emerge after we know in March 2017 what is going to happen. I'm recording this in the end of January 2017. We've now got some idea of where we're going with Brexit, but I think the longer term implications for membership of the ECHR and the convention itself could well be a main electoral platform in 2020. It's certainly been suggested, and that means we could be looking at the changing of the Human Rights Act into a new piece of legislation called the Bill of Rights. We don't know where we are at the moment, but at least we've got some idea that that's the way the government is thinking. Bearing in mind they are very, very substantially ahead in the polls, the likelihood is that they will carry out their manifesto commitments. Article 8, of course, is the right to a family life, and it's emerged in recent years as a key area of controversy in human rights reform, of which further comment will be made later. It's the subtitle of the book, therefore, which tells you, the reader, what it's all about and what its aims are. Unfortunately, as I said, the title itself is a trifle confusing, probably lost a bit in translation. The term family forms, which is what it's got there, appears to refer to the changing and ever more complex structures which now characterise the modern family, i.e., in other words, step parents to same-sex relationships, partnerships and so forth. In other words, it's the structure, how a family unit is formed. I think that's really what they're talking about. But as I say, the title is a bit misleading. The book, by the way, is a compilation of essays, which is why it's got all obviously contributors. It's national reports from 11 European countries and other research gleaned from a workshop sponsored by the Swiss Society for the European Convention on Human Rights, which was held in Zurich at the end of 2013. As I've said, I don't see any changes taking place in the short term. In the longer term, there could well be a lot of change, but I think at the moment this is a very valuable book. The two expert editors hail from the University of Zurich itself, one of whom is a judge at the European Court of Human Rights. The other contributors come from top universities and institutions, including Cambridge. The book therefore presents a high level of academic work by high-level academics who generally, and rather discursively, have aimed to set out a satisfactory case for the retention of Article 8. I don't know what's going to happen. I would have thought that part of Article 8 will be retained, whatever happens, because it makes sense, but it'll presumably be in a slightly different, modified wording in the Bill of Rights, but we'll have to wait and see. Of course, post-Brexit, the book will certainly add fuel to the debate on whether we retain Article 8 or not, especially in the United Kingdom, where the bulk of public opinion currently favours its amendment and reform. I'm not talking here about readers of the Daily Mail and other newspapers, but clearly there is a quite strong feeling that, if anything, Article 8 have overstepped its basic aim and usage. And I think that's the problem, because we've had some unfortunate cases which show up the legal system to be a little bit of a joke. It isn't a joke at all, but you do have to realise what the strength of feeling is about the use of Article 8 to allow people to get away with things which they patently shouldn't get away with. That's the basic argument. Now, even more radically, of course, there are those who feel it's a fundamentally flawed article and should be scrapped altogether, as all too often is being used, of course, by non-UK criminals as a means of avoiding deportation. That, I think, is changing, even as I speak, because I think there is a different approach to the way in which people are going to be removed from the United Kingdom when they are not allowed to be here. And that means that I think the Article 8 use, that the little loophole is going to be stopped. Let me conclude by saying that nonetheless, with its rich reservoir of research and comment, the book contributes admirably to the ongoing debate on the jurisprudence of the European Court of Human Rights, and will no doubt be welcomed both by practitioners and scholars specialising in this area of law. I certainly welcome it. I think it's interesting because you are talking of a high standard, academically, scholastically, of jurisprudence, and I think that is what will actually be on offer for a lot of people. Long term, I don't know. The publication date is cited at 2016. Let's have another quick look. Red cover, paperback. It's quite heavy actually as a book, but very much the style, the house style of Intercentia. I'd like to thank Tom Shears very much for sending this book to me. Let's just open it in the middle. Family Forms and Parenthood in Germany. Effect of the European Court briefings, sorry, rulings rather. So you see, it covers a very wide range of different things. As I say, you've got the footnoting at the bottom. Just on the spine, you'll see there's a number 40, because this is a catalogue book in a whole series of books from Intercentia. Anyway, thank you very much to all of you for sending it to me. And watch this space, because I think there's going to be an awful lot of exciting stuff happening, certainly in 2017 onwards. Thank you to all. Bye-bye.